Hey guys, what's up? Would you guys like to see what you get when you invest in my Judicial Wrongful Foreclosure lawsuit package? I'm going to show you the zip file of the 12 documents that will be sent to your email connected to your credit card after checkout. I will provide a quick summary of each document and the strategy behind using the document. I will also explain the difference between the attorney's conventional foreclosure defense and my non-conventional foreclosure defense strategies and the benefits of using my strategies. My goal is to help you get your foot in the court with your civil claim that includes a strategy to block the eviction process. The number one goal of foreclosure defense is blocking the eviction process, not blocking the sale. And I know that sounds funny, but I'm going to explain to you right now why that's important. Because the sale can take place, and as long as you got your documents filed in court and created a title dispute, you will block the sale from going forward. But it can take place. Once the sale takes place, then the judge has to allow a period of time before he signs over the deed to the new people. And in some states, there's a redemption period, and that redemption period has to be exhausted before the judge can sign the deed over to the third-party buyer. The problem is, if you don't focus on blocking the eviction process, you could be kicked out of your house before you even get a chance to fight for your property. And that's what they try to do. And they know that if they're able to get you evicted while you're trying to fight, if they're able to get you evicted, it's going to cause some serious problems. If they're able to get you evicted, they know you're going to have a hard time fighting because you're going to be trying to figure out where the hell to move your family to and how to put and where you're going to live and all that. And then you're going to have to do the fighting part later. It's a lot easier to do the fighting while you're still in your house. And that's why it's most important to have a goal and a strategy that's going to block the eviction process. My name is Guy Neighbors, and I'm with Advocates for Justice Paralegal Service. And I have been through what you're facing. And everyone I contacted wanted at least $5K to help me. And this was back in 2012. So I know that's increased at this point. The attorneys, when I was going through what I went through, the attorneys treated me like I was stupid, and that pissed me off. So I decided to do something about it. And this is what I came up with. This video will be part of a playlist titled Lawsuit Package Instructions. Now, I'm sick of seeing these attorneys getting away with stealing from people. So I decided to learn the loopholes in their program and structure document packages that will attack these loopholes. In my program, you will be going into court attacking the loopholes in the attorney's program that rob the court of jurisdiction. The attorney's fraud is why I don't add all the nuts and bolts of your situation and modification and what they did and all the lies that they told you. You need to be addressing the attorney's misconduct, not the alleged mispayments. People should always remember the whole mortgage process is a scheme. It's fraud. It's a scam. So if you go in arguing the scam in the middle of the process, you're still arguing the scam. At the end, you still have fraud. So you're not going to get anywhere arguing about what they're saying was the problem. You need to argue what they did wrong that caused this problem. And that's what we do. I will also help you learn how to recognize when the court's violating your rights by failing to follow proper procedures. In my program, you will be going into court attacking the attorneys for filing an illegal foreclosure against your property, acting as a debt collector. That's one of the things most people miss. Most people miss having the right person down as the number one defendant when they're defending their property. They believe the crap the attorneys tell you, which is the lender's coming after you. Well, it's not the lender. By the time it gets to the situation where you're at now, the lender's already cashed in on the mortgage insurance and claimed it on their last loss on their taxes. And then these third-party debt collectors come in and they buy the debts for pennies on the dollar, and then they attack your property acting as a debt collector, not working for the lender like they try to make people believe. If you think I'm off base on this fact, check your paperwork. If you're in a judicial foreclosure, check the petition and see who signed it. Whoever signed that petition to execute the foreclosure against your property should be the #1 defendant on your lawsuit. And if you check, you'll see it's the attorney. And in a non-judicial foreclosure, you would need to check the notice of default letter or the acceleration and cure or whatever they call it. That letter they send you telling you have to pay all this money plus this extra money over here, or they're going to sell your house in 30 days. The attorney signs the notice of default letter. Notice of default letter should have been signed by the trustee, and it never is. It's usually signed by the attorneys because they have these processes in place to speed things up. And when they're speeding things up, you're getting the shaft. In this video, I will show you the documents you will receive when you invest in my Judicial Wrongful Foreclosure lawsuit package. I will review each document and the strategy behind using them. You will see the documents are real and structured by a person who has little respect for the attorneys. Now, before we get into all of that, if this is your first time here and you want to learn how to smash attorneys in the face, subscribe and click the bell down below so you don't miss anything, because we're finna get rolling. Now, I have a couple of please do not do things that I want to talk about. If you get in my program, please do not email me your foreclosure documents or documents from the court without my consent, because that's not what I do. It's up to you to handle all that stuff. Now, there's time on occasions when I will request to review something or look at something and we're having a problem, but please don't send me documents or send me court documents or foreclosure defense documents or anything that I have not requested. And I want people to understand too, is that my program is separate from what you've been doing already, okay? And we'll go over that later when we're talking about the differences between the conventional and the non-conventional programs, and you'll understand why my program is separate. So I don't really go in and try to help you figure out how to do what you got going already. I have a whole new different program that we're going to be setting up and getting in place. And that's the program that I offer my help with, because I put that program together. And I put that program together using our Foreclosure Rescue Facebook page. It's a private group. And many people in that group are using my strategies and documents. And I have people from the East Coast, the West Coast, from all over working in the group. And I don't really want to mention the names of exactly what states because I don't need to. I'm sure there's people trolling this, trying to figure out what's going on. And they're welcome to come and stick their nose in my business if they like. It's not the first time that they've tried to shut me down. But I do like to be careful because it's a little hard for me to help everybody else if I'm defending myself. Oh, if you guys are emailing me something or if I ask for something, please don't email me an email with other people in it, because you may trust these other corporations that offered to help you or said they're going to help you. And I don't trust very many corporations to do this because I haven't seen anybody actually help anybody. So I don't want my name connected on the emails that we're talking about and what's going on with other people on them, because it's just a liability and a way for other people to figure out who's helping you and try to get in the way. The other thing that I want you guys to do is, please, before you click that button, before you make the decision to join my program, go to my website and review the disclaimer. When you do that, you will understand where my responsibility ends and your responsibilities start. And it's really important for you to understand that, because my job is help you get your foot in court and provide you with strategies and a game plan that's going to block the eviction process. The rest is going to be up to you, because I'm not an attorney. I'm not going to answer for you to them. Or now, with that said, you know, most of the time they try and respond in a pattern. There's a pattern of their responses, and we've already had them because we have so many people that have been working and doing this. So I can give you a little bit of help, but I don't want people sitting at home waiting for me sending me stuff and waiting for me to respond to it, because I have a lot of phone calls that I take. And that whole part is going to be up to you guys. I am here available to help, but that's it. You're the lead person running the show. It's your responsibility to keep up with your lawsuit. It's your responsibility to respond to them and to keep track of everything. Now, most people think it's difficult to structure and file a wrongful foreclosure lawsuit to defend your property. And, it probably, their thinking is probably correct. But fact of the matter is, it's not that difficult if the lawsuit is structured and all you must do is personalize the documents and get them filed. I provide the coaching to help you understand the documents and answer any questions you have about the process that I can answer. So now we're going to get into the zip file here in a couple of minutes. But before we open up the zip file and start going over the documents, I want to let's touch on one thing. I want to explain the difference between conventional foreclosure defense and non-conventional foreclosure defense. So the conventional foreclosure defense, when you go to the attorneys and you ask them for help, they take all your money and they tell you have three options: loan modification, short sale, or bankruptcy. Okay, and you all know what those options are, so I'm not going to spend a lot of time on those options. But what I will tell you is that the bankruptcy has helped some people and it has stalls. But there's a lot of the times your house the stay gets lifted after you pay all that money and jump through all these hoops. The stay gets lifted and your house gets put back into the foreclosure. And the attorney said, well, I don't know what happened. The judge, well, what happened was the attorney didn't object. Okay, that's what happened. The attorney did not object. And in most cases, the attorney and the judge had already decided they were going to do this. They were going to take your money for a few months, make you make some payments, and then eventually put the house back in foreclosure so the attorneys can sell your house. And that's who's actually selling your house, the attorneys. The attorneys are trying to sell your house because of an alleged debt that they think you owe, when you actually don't owe the debt, because your house the alleged loan was actually created with your own signature. And I know I mentioned that a few times. People thought I was crazy. It's just really sad to see people believe what attorneys have been feeding us for years, even though they can see that this is not right, what's going on. So let's just jump right into it. I'm going to open up the share window here. Okay, so here, when you invest in my lawsuit package and you check out, this zip file right here will be sent to your email address connected to your credit card. And I'm going to open up this zip file, and it opened up here. So I'm going to move it down here so you guys can see it. When you open the zip file, this is what it looks like. It looks like it's just one document. Yeah, I had a few people call me excited about this. I'm going to relax. You have to click it again. You have to double click it again. And when you double click it the second time, it opens up to show all of the documents. There we go. They're supposed to open up to show all the documents. There we go. So these are all the documents in the non-judicial foreclosure package. And like I mentioned earlier, we used our Facebook page to figure out what we need to do. And the way we do that is our members in the group contact me. So I get real-time feedback on how these attorneys are trying to get liable for what they're doing. And that allows me to make changes to the document package. It allows me to add additional documents to it, whatever we need to screw that door shut so they can't use it again. And that's why we ended up with so many documents here. The non-judicial foreclosure package actually has 2 or 3 more documents than this package has. But you know what? We're learning. And my goal is to put this package together that'll cover everything that people need in this fight. So let's just get started here on the first document. So the first document we're going to look at The first document that you have to be concerned about is the Judicial Wrongful Foreclosure lawsuit document. We're going to open it up. So, yeah, I'm only going to show the front page of this. I just want to let you guys see that it's real and it's not very complicated to personalize. Now, I have a couple other documents. I'll show you more of the document so that you can see what's going on with it. But this document, we're just going to take a look at the front page. Now, here is where you would have to put your address, your John Doe or Jane Doe, and your address goes here. The court heading here, your name here, again, you're John Doe. The attorney's name here as number one defendant, the law firm as the second defendant, and the last servicer. We only add those three people to the list. And the reason we do that is because we want to force the attorney to have to protect the servicer. Because what happened, the servicer claimed the alleged loss on their insurance and their taxes, okay, and then they sold the alleged debt to the debt collectors. That's my opinion based off the signatures on the paperwork from the people that I've been working with. So by doing it this way, you're forcing the attorney to have to protect the servicer, which creates a problem in the end. But the biggest difference between the conventional and the non-conventional is the conventional foreclosure defense is set up where the attorneys have a program set up where they get to drag you into court and they take all your money for going into court with you, and then in the end they kind of kick you to the curb and you're on your own in the end. Now, the non-conventional program is set up to hold the attorneys accountable for the stuff that they're doing. Because I know most people, by the time you get to where you're facing foreclosure, you start looking into all this stuff. And I know people see that what's happening to them is not right. So when you do the non-conventional foreclosure defense and you're holding an attorney responsible as the number one defendant, that creates a problem for the attorney. Because the attorney can litigate a case they're a party to and they can't represent themselves. One other thing that people don't know is that attorneys are not allowed to go into court and represent the law firm they're affiliated with. A corporation cannot go into court representing itself, per se. A corporation has to have an outside attorney represent it in court, and that's the rule. So here you see, you would have to go in, there's, your John Doe or Jane Doe, and his or her, your address again. On that, the rest of the document is the same. All you have to do is fill out, is replace the red font with your information, and then turn the red font to black. Now, the biggest challenge that I have from people with this is people forget, and they want to add all of this other stuff that happened in the lawsuit. And you don't need to do that. Right here, you reserve the right to amend in case you need to add anything or change anything. But you need to remember, going in arguing the stuff that the attorney said is not going to help you. You need to be arguing what the attorney did wrong and how they're violating your rights. That's what you need to argue. If you go into court and you argue all of that stuff that happened, the judge is going to assume there was a contract, and there was not a contract. There is not a contract. A contract has to have two signatures on it. And that promissory note that they're saying what's contract only has one signature on it, and that's your signature. The petition that they file against your property only has one signature on it, and that's the attorney's signature. Nobody from the bank ever signs anything. And that's because the bank is not the one foreclosing. The problem is the foreclosure lawsuit petition against your property has a fatal flaw. I mean, there's a lot of problems with it, but this is the one problem that, now, aside from the fact that the money was created with your own signature, okay, the next problem is there's no witness. There's no witness, there's no injured party. Without a witness and without an injured party, the court does not have jurisdiction. We like to make sure that we're addressing in our lawsuit stuff that the judge and the attorney don't want to argue about. Because the way the conventional program is set up, when the argument starts, the judge gets to help them. And we already know how that goes. So we like to go into court addressing stuff they don't want to argue about. And we like to address what the bank did wrong and what the attorney did wrong in the beginning. The judges are not in a hurry to sign their name on stuff that's showing what the bank did wrong. And they know that if they deny you and you appeal it, then it's going to become case law. Now their name's going to be connected to this stuff showing the fraud that the bank's doing, and then the bank's not going to want to keep giving them money or whatever it is they do to get them to throw us under the bus like they do. So that's something to keep in mind. So the next document is going to be the restraining order. Now, this is the Judicial Temporary Restraining Order, permanent injunction, and demand for emergency hearing because of the pending lawsuit in federal court. So, as you can see here, you're going to have to, do the thing here with the red font. When you file this, now the temporary restraining order, you can't file. The court won't recognize it unless you can verify that you are facing immediate injury. If you can show you're facing immediate injury, then you can file it. So basically, if you're looking at eviction, if you've been served the papers for eviction, or if the third-party buyer is trying to, harassing you or whatever, then you can throw a temporary restraining order on the table. When you go to file your documents, okay, you don't want to have like all of them and give them all at the same time. Okay, one at a time. I just give them one at a time to file. And the reason I do that is it lessens the opportunity for them to give you a hard time about filing your stuff. So it's better just to give them one at a time and keep your stuff in a folder. When they bring back the lawsuit with a case number, then you can whip out the restraining order if it's time for you to file that, and you hand write the case number in on the restraining order, and then you file it. And the same thing with the sanction motion or any other documents that you're actually filing. You want to get that first document filed with the case number so that you can file the rest of your stuff and put that case number on it. Okay? So let's just scroll down. That's pretty self-explanatory. So we're going to go on to the next document, and that's going to be the affidavit template. Now, this is the affidavit that we put together, and your details go here. But what you need to make sure is that the details that you're putting here are the details from your lawsuit, okay? From the wrongful foreclosure, judicial wrongful foreclosure lawsuit. Those are the details that you need to mention here, okay? You don't want to start putting all this stuff and the things about the loan modification and all that stuff here. You want this affidavit. You want this affidavit to match your to support your lawsuit. Okay. So the things mentioned in the lawsuit are what you need to summarize and put in here. And you can see that's just a few pages. So we're going to move on to the new entry of appearance. Okay, the entry of appearance of a state citizen. Now, there's a video that one of the clients sent me. It's on YouTube, and it's called How to Get on the Do Not Detain List. And that video teaches you how to fill out your passport application so that you can reclaim your state citizenship. And once you reclaim your state citizenship, the important thing about that is when you can verify that you're a state citizen of the Republic state of the state you're born in and not a citizen of the federal government, then you're no longer subject to the court's statutory jurisdiction without an injured party. But the goal is to change your status so you're not so that you're not a citizen of the federal government when you go into federal court. And I think that is the way that we need to attack getting ourselves in a court of record, getting ourselves into a common law court. And I think that's the way to do it. And we're still working with that. But this is the start. Now, I put this document together, the entry of appearance of a state citizen. I put this document together because I had people who had attorneys throwing them under the bus. And when they fired the attorney refused to go sit down. So this document will force the attorneys to go sit down. And basically in this document, you're putting all officers of the court on notice that no documents will be filed or will be added or removed from your case without your signed written consent. And you obviously have a certificate of service. Now remember, in your certificate of service, you need to make sure that you add all of the parties that's on the front page of your lawsuit to the certificate of service, and make sure that everybody gets copies of everything. So the service, the actual lawsuit has to be served. You will need to review the process of service for your state, because each state is a little bit different. And once you review on Google the process of service for your state, if you have any questions, you can contact the court. And what the court tells you is different than what you researched, then maybe we should have a conversation and try and figure out where the problem is. Because if you don't have that process of service perfected, then your lawsuit is not going to be recognized by the court. And that's going to be pretty important, because a lot of people, by the time you get around to getting help from us, you're already like almost at the end of the road. So you can't afford to have any loose ends get in the way with you smacking them in the face. The fifth document is the United States of America Affidavit of State Citizenship. So this document I put together myself. And the reason I put this document together is, well, when you fill out the passport application and all that, it costs like $150 or something, and you got to wait for them to send you back your passport card showing that you're a state citizen of the Republic States you're born in, and blah, blah, blah. Well, I have people that don't have time to wait for that stuff to come back. So I put this affidavit of United States of America Affidavit of State Citizenship together. And it's important for people to remember there's two United States. There's United States of America, which are all of the states together. Then there's United States, Inc., which is the federal government. And the federal government has tricked everybody into thinking that you're citizens of the federal government. And that's not true, because no one can be a citizen of a fictitious corporation. No one can be born in a fictitious corporation. It's just amazing how they pull the wool over our face and tell us so many lies that we've believed for years and years. So this document here, the United States of America Affidavit of State Citizenship, is designed for you to, well, you can see you have to fill in a couple of places here. Now you will need to attach a copy of your birth certificate, a certified copy of your birth certificate would be best, to this document. And I would file it in your case also. Once you attach it, when you go to file your lawsuit, you should file both the affidavits on the same day, but not at the same time. Because remember, you got to get the first one filed, and then you'll have to take that one and write the case number off of the original, off the lawsuit document onto the other documents before you give them to the clerk to have them filed in court. And this document was put together, and I'm just added into all the packages for people to use to help them change the status in court. So you can see it's pretty self-explanatory. Just put your name in there, your address, and where you were born, and change all the red font to black. Pretty simple. So we're going to go on to the next one. So the next one is a demand to strike the notice of appearance. Now, this document I really like. Demand to strike the plaintiff's notice of appearance from the court record. A corporation cannot represent itself in court. And this is the document I was talking about before. So usually what happens when you add the attorney as an M1 defendant and their law firm as a second defendant and their last servicer as a third defendant, what happens is the attorneys have a hard time finding someone to help them because they can't litigate the case they're party to and they can't represent themselves and we know all that. So they get on the phone and they have to find outside counsel for how that phone call would go. But I think the other attorneys would, if I was the other attorney, the question I would ask is, why do you need my help? Well, then they'll explain that they filed a foreclosure and the foreclosing party filed a wrongful foreclosure lawsuit in federal court, a higher court against them, and added the attorneys as a #1 defendant and the law firm as a second defendant, and the third defendant is the servicer. When the new attorney hears that, they're going to realize that, this homeowner's figured out that this is not really a foreclosure, it's a debt collection, and the attorney collecting has no standing and no consideration in the deal and has been added to the lawsuit because of all of that. The other attorneys are I wouldn't be in a big hurry to help someone in that situation. And I think that's kind of the problem that the attorneys fall into. And what ends up happening in a lot of cases is they have someone from their law firm step up and file the documents in court and try to defend them because they don't think attorneys think we're stupid. That's pretty much in a nutshell. They think we're stupid. You will file this demand to strike the attorney's notice of appearance because the attorney can't represent the law firm they're affiliated with, and the law firm can't go into court with pro se representation. And there's no circumventing the rule. They're very strict on this rule. Now, the attorneys will try, if the judge tries to allow them to go into court, then have documents we can file to jam the judge up for not following the rules and the procedures. Remember, we talked about that earlier in the video. Now, one of the things I want to tell people too is when you join my program, when you invest in my program, any documents you need to help you with the goal that you're trying to accomplish for joining my program, I will send you free of charge. For instance, if you need documents because the magistrate judge got involved without consent, then I have documents for that, and I'll send them to you free of charge. I'm not going to nickel and dime you like attorneys do. And that was the reason behind trying to put the package together with everything you need. So you can pay one amount of money and take the package and go start getting things done. Now, number 7. The motion to challenge eviction court's jurisdiction. I like this one too. Now, in the beginning of this video, we talked a little bit about blocking the eviction process, and this is how we do it. When you get to the eviction process, okay, the one thing that people don't realize is that eviction court can only make a determination on immediate possession. They cannot make a determination on title dispute. And my research has shown me that eviction court doesn't have jurisdiction because of that. It doesn't have jurisdiction because the amount in controversy. It doesn't have jurisdiction because the attorneys are considered a foreign agent, and as a foreign agent, they have to file their lawsuit in federal court. These are just a few of the main reasons why eviction court does not have jurisdiction, and also reasons why the foreclosure court did not have jurisdiction as well. So what you do is when you file your lawsuit in federal court, that creates your title dispute. And you want to always refer to it as a title dispute. When you're talking to people from the court, when you're talking to the stupid attorneys from the other side or whomever, you want to refer to it not as a lawsuit, refer to it as your title dispute, because that title dispute is what you're going to use to stop all of this stuff, the eviction process, and give yourself a chance. And the way we do that is we use this motion to challenge eviction court's jurisdiction. You want to attach a file stamp copy of your title dispute to this motion to challenge eviction court's jurisdiction and file that in eviction court. And when they see that you have a pending title dispute in a higher court, they're done. But I know they don't like to get smashed in the face, and they have a hard time doing the right thing, going and sitting down. So I have another document that we're going to talk about here in a minute to help you make sure that this works out the way it's supposed to. So your motion to challenge eviction court jurisdiction, you can see here's where you would put, and where it says blue here, I put that in blue because you don't need to change that. All you need to do, you need to remember to add a file stamp copy of your wrongful foreclosure lawsuit and a copy of the restraining order, if you're using a restraining order. And you add these two exhibits to this motion to challenge eviction court jurisdiction. And what I always do when you add these exhibits, okay, like if this motion is 10 pages long, okay, and you add 5 more pages of exhibits to it, okay, when you're all done and you're ready to take it in and file it, before you do that, the last thing you want to do is go through and renumber all the pages. You want to go page 1 of 15, page 2 of 15, page 3 of 15, page 4 of 15. And the reason you do that is because when you do that, it blocks them from removing any exhibits from your document. And I've seen that happen before. It got lost. We don't know. It came, and this is all we got. They have all these lies. But when you do it this way, they can't lie themselves out of it, and they can't remove stuff from your package, from your lawsuit, without it being very obvious. So once you add these exhibits, then you want to turn this blue to black, just like you did the red when you're done, okay? And I'm just going to scroll down so that you can see a little bit about. This is a very serious document. I put a lot of research in this, because when I first started putting these packages together, okay, I went through the judicial foreclosure process, not the non-judicial. So I had some things to learn. People were investing and they were calling me, hey, we got my lawsuit filed in federal court, but they're still trying to kick me out. I'm like, well, how the hell could that be? Well, yeah, it's pretty messed up what they do. So I had to go back to the drawing board and figure out a way to block the eviction process. And this is how we block it. The eviction court can only make a determination on immediate possession. So when you file this, and then you file the next document we're going to talk about, the notice of removal, you can remove the eviction case right out of eviction court and move it over to federal court and connect it with your title dispute. And once you do that, you have federal court either vacate any judgments against you that the lower court had in the eviction court, or make the whole immediate possession issue moot. And the reason that you're doing that is because immediate possession has to take a back seat until the title dispute's been settled. And that's what you asked them to do. And that's worked just fine. I had 5 people in one state that had the same attorney. And yeah, he was like really, really grumpy in court. And all 5 of those people are still in their house. And their situation, they contacted me back in October of last year. And those people are in my Facebook page as well. So we're going to move on to the next one. The notice of removal. I like this document too, because it's really fun when you get done being abused by the courts. It's really cool to be able to go in there and just take the stuff right away from it and move it over there, and they can't do crap about it. I love my job. So the notice of removal, and here it is. And if you'll see, it says notice of removal. This is not a motion, okay? When you use this document, what you're going to do is you're going to take a copy of that motion that we just talked about, that where you challenge the eviction court jurisdiction. Remember, we just talked about it a minute ago. You're going to take that motion along with the attachment, the exhibit, which is your title dispute that you have filed in federal court. You're going to attach those, the motion to challenge jurisdiction, the file stamp motion to challenge jurisdiction that you just filed in state court with your title dispute attached to it, and you're going to attach to this document as an exhibit. And you file this notice of removal in federal court. But this document is really, really freaking sweet. And it just moves everything right out of the eviction court, and they can't do crap about it. And I love it. Then we're just going to scroll down so you can see it's very short. You don't need to say much. That attachment, when you attach that file stamp copy of the motion challenging eviction court jurisdiction, along with the attachment showing your title dispute that you got to file in federal court, that's all you need on this. Now, I know I keep saying that the next one is my favorite one, but this motion for sanctions really is one of my favorite ones. Now, this motion for sanctions, I'm going to change this and make it for $5.5 million. I like to put the same amount on the motion for sanctions as I have on the actual lawsuit. And the reason you're asking for sanctions is because, according to Rule 11, these attorneys are supposed to do a reasonable pre-filing investigation before they file these lawsuits and go after people's properties and cause all this freaking harm. Okay, but they never do. And your argument is simple. I like to keep it simple. Your argument is simple. Your argument is this. Had the attorneys did a reasonable pre-filing investigation, they would have uncovered everything that you have in your 24 or 25-page lawsuit. Simple. That's it. And when you file this motion for sanctions against the attorneys, it also causes attorneys to have to hire outside counsel. Because this is kind of like having a counterclaim inside of the claim, or a mini claim inside of the bigger claim and a mini claim of something. But yeah, so attorneys don't do things this way, but we sure can, and they have to respond to it. So usually what I have people do is not file the motion for sanctions until you get down the road. You want to save this and use it as a blocker to block them from violating you, so to speak. And a lot of times the best thing to do is to hold off on this motion until you see if they're going to respond, or if they're going to have a third-party person come in and respond. And if they have a third-party person come in and respond, then you can hit that person out with the sanction motion, because the lawsuit already had the other people backed in the corner, the other attorneys backed in the corner. The new attorney comes on, you can slap him in the face with the sanction motion, because they're taking on for the other attorneys, and they're supposed to do a reasonable pre-filing investigation just like the other ones did, and they never do. They don't investigate nothing. They just go by the records. And as a matter of fact, whenever they file a affidavit, it's usually a defective affidavit, because it states that they reviewed the records, and you're actually getting sued by the records. Well, you can't cross-examine the records. That's ridiculous. But they pull that crap all the time because people don't know. Well, we're learning. And you can see in this motion for sanctions, we don't play around, okay? The affidavit is defective. There's no competent fact witness. The attorneys cannot testify. Fraud and deception on the court. Now, I don't use the word fraud too much, and I don't focus I don't hang my hat on the fraud, okay? And if you'll notice in my lawsuit, it don't say anything about fraud. It may mention it in one place in the very back. And the reason is, people forget that these attorneys are the ones that structured the legal system, the current legal system. And they structured it for them, not us. Oh, and whenever you argue fraud, there's like 7 things that you gotta claim, and then you have to connect all 7 of those to each count. And if you miss one, then they move to dismissal, failure to state a claim, release, because they couldn't understand what you were saying. Yeah, I know it's bull crap, but that's the way they roll. So I don't mess with the word fraud. If I use fraud, I use misconduct, deception, any of those things. You know, if you keep it simple, there's less arguing. Because when the arguing starts, the judge gets to help them. And that's the way that goes. So you got to keep that in mind. And keep that in mind when you start thinking about all of this other stuff that you want to add into it or whatever, because you emotionally are wrapped up in here. You want to kick these people's butt. Okay, you got to remember, this is the way to do it. Okay, not that way. Because that way is, we're getting close to the end. So the next one is a civil cover sheet answers. Okay, so when you go to file, they have forms that they want you to fill out. Now, I always tell people to print these forms off and have them filled out before you get down there. It's a lot less stressful, and it makes you look like you have more of an idea of what you're doing, which means that they'll be able to, they'll think less about giving you a hard time about filing your stuff. Now, when you're filing your stuff, there's a couple of things you need to remember. Okay, if they're giving you a hard time about accepting your documents, okay, this is what you need to say to them. You need to ask the clerk that's giving you a hard time, do you have authority to make a legal determination on my pleading? And they don't. And I haven't had one person hit them up with that continued to get harassed. The other thing that you can do is every state has a statute, a filing requirement statute. And if you look that statute up, that statute is real liberal. And when you go to court, all those other rules that they're trying to make you follow are called the local rules. And those rules violate the Constitution. And in my opinion, those rules are put in place for attorneys to use to help speed things up through court. Yeah, and anytime things are getting sped up through the court, you're getting a shaft. So that's just the way that works. And that's a really good way to tell where the problems are in the process and the procedures, okay? Any process and procedures that are put on the table to speed things up are violating your rights. So you want to keep that in mind. The other thing so what I always tell people to do is to look up that filing requirement statute and add it on the front page of your lawsuit. Add it someplace on the front page there. You know, this document was filed pursuant to the filing requirements for the state of Kansas pursuant to statute 785291, whatever, okay? And when they started giving you a hard time about filing your stuff, you can tell them, hey, you know what? This is filed according to the filing requirement statutes right here, says section 85792 for our state. I don't understand how that's different than what you're telling me to do. How could that be different? And then make them explain to you. Yeah, but that's it. If you have it in there, they'll back off and leave you alone, because they know that you know what's going on. They're not going to be able to pull a wool over your face. So that's important to know. The other thing that you need to keep in consideration too is they'll try to get you to fill out all of their forms. They have a form that they want you to fill out. That's the complaint. Yeah, it's like what, 3 pages, maybe 3 pages. I don't know. It's a few pages. But what I do know is that it doesn't address anything that you need to have addressed. And if you take that form and you fill it out and you sign it and you add it to the back of your lawsuit and you tell them, hey, here's my lawsuit, but here's your form. When they take it, they're going to put that form on the top, and the rest of your lawsuit is going to be just set in the collecting dust. Because remember, they want to do stuff so it can hurry up, and they ain't trying to have you in controlling anything or giving them a hard time or interfering with their efficiency. Okay, they're not trying to have that. So what I would do if it was me, I would take that form, that complaint form that they give you, if they tell you they want you to fill it out or whatever, I would just take it and stick it in your folder underneath everything. And just tell them, look, this is the complaint that I want to have filed. You want to always refer to your legal team. My legal team spent a lot of time putting this complaint together, so we're going to use the one that my legal team put together, and I'm going to take this one and stick it over here and take it home and use it in the bathroom later or something, I don't know. But that's what you need to do. You need to make sure that your complaint is the only one on file, and that piece of crap that they hand you, okay, that they would like you to fill out, you need to make sure that that's home in your bathroom trash can or the toilet. Now, I put this together to help you with the civil cover sheet. You have to file a civil cover sheet to get them to accept your stuff. And the civil cover sheet has Roman numerals on it. And those Roman numerals I have here. And what's next to the Roman numeral is what goes like here, number 3, the citizenship of principal parties. That's what you put in there. That's what it says. Then this is what you would write down here. And this is what you would write in for number 4 and so forth. So I tried to, now I don't do the court stuff. That's up to you guys to figure out, because courts in different states are different. And I'm not trying to tell anybody to do something that I don't know or I have a good idea of, actually that I know. If I don't have a good idea, I'm going to tell you that and send you to go figure it out. Because any of these things, I can tell you right now, when they read what you're bringing to the table, they're going to be trying their best to pick at it and figure out some kind of way to get it out of their face, okay? So you need to do your research on the filing requirements and what's required so that you'll know when you go down there. And then you'll be able to say, when they tell you, hey, wait a minute, that's not what it said. Oh, wait. I have right here where the filing requirement is for this state, and it doesn't say any of this stuff you're telling me now. I'm confused. And then you can go back to what I said earlier. Do you have authority to make a legal determination on my documents and make them shut the hell up and leave you alone? So let's move on to the next one. So that you can see it. Now, this is the cease and desist letter. It shows on the how to get on the Do Not Detain List video. I actually hand typed this up. You can't copy and paste nothing off video, so you just have to take your time, hand typed it up. And I included it in all of my lawsuit packages. So when you can verify your state citizenship and you have debt collectors sending you whatever, I would just print this out, personalize it, print it out, and send it to them. Because if you can, and I would attach a copy of your documentation verifying your state citizenship status and just send it out to them and keep track, because usually it takes 2 or 3 times before they leave you alone. But here's the deal. Once you can verify your state citizenship, you're no longer liable to the court's jurisdiction for all that stuff that they're trying to do to you. Third-party debt collectors can't sue you. They can't come after you without an injured party. And they never have an injured party. And that's the reason why you want to do this. And the other reason why you want to do this is to force the federal court to respect your state citizenship status and not treat you like you were a citizen of the federal government and presume that everything that the attorney's saying is correct and everything that you're saying is full of crap and throwing your stuff out the door. So this document is added to the list for people to use. And as you can see it, it's just 1-page document. You fill it out and you attach your documentation to verify your state citizenship to it, and you stick it in their face. And I would send a copy of this to the attorneys that's harassing you also. Yes, I would. Along with all the documentation, after you get all done filing all the stuff in court, I would send them a copy of this along with any other documentation that you have verifying your state citizenship, and let the attorneys know that you're going to be suing them again for violating you as a state citizen when you get done with this other wrongful foreclosure situation. See how you like that. Okay, so now this is a wrongful eviction lawsuit that we put together. And I was doing some research one day, and there actually is a claim for wrongful eviction. And I was like, oh, this is sweet. But there's a couple of things you got to know before you can use this. Now, this is written up to attack the third-party buyer if the third-party buyer has been provided constructive evidence that there's a title dispute. And if you provided constructive evidence to the third-party buyer there's a title dispute, and they continue trying to evict you, okay, and like say you're, for instance, you're appealing, your title dispute's in an appellate court or whatever, and they're still trying to evict you before the final judgment, then you can stick this clean in their face. And that's what it's for. And this was one of the documents that we added to stop the nonsense on the back half, where they just try to go ahead and keep doing everything anyway and ignoring the fact that you got your lawsuit filed over here and they're supposed to stop. So this will help you with that. And you can see there's reservation of rights, third party, all the parties. It's pretty self-explanatory. So that is the 12th document. You're facing a judicial foreclosure and you want to get your wrongful foreclosure lawsuit filed in federal court to get control of the unlawful foreclosure situation, head over to our website at winningincourtnow.com and get what you need to defend your property today. Now, what I ask you to do is once you get your package, you should review the first document that you got to file. Remember what that one is, the wrongful foreclosure judicial lawsuit. Review that document and highlight any areas that you have questions on. And then get on the phone and give me a call, and we'll get on the phone and go over all of your questions at the same time. So once you start personalizing the document, you won't have to do it over. Now, I have people, tell me, I'll just send it over to you. No, I don't have time for that, and neither do you. And like I said earlier, I don't want people at home sitting around waiting for me to get the stuff while they're about to get kicked out of their house. Okay, it's up to you to take charge and get this stuff done and get it handled. So keep that in mind. If you're ready to go, get over to my website, make your investment, and let's get going. Oh, one other thing before I forget, I want to show you guys, my new award that I picked up in Chandler, Arizona from Excellence in Foreclosure Defense. It's not as cool as a Super Bowl trophy, but it's pretty cool. So you guys, don't forget, subscribe down below. Subscribe to the YouTube channel, click the bell so that you don't miss anything, and I will see you in the next video. And the next video, we're going to do the same thing here, but we're going to cover the non-judicial package. So I'm going to have a video going over each package and showing you the front page of all the documents that I have on my website, so people will have a better understanding of what they're getting and what they're expected to do and all that when they're considering getting in my program. So we'll see you in the next video.